The Sparrow Case was pretty monumental in the history of Canada, actually, and particularly for Aboriginal peoples. And Musqueam was the spearhead of that. What happened was that over time, the Department of Fisheries and Oceans and the major fish processors reduced the role of the Aboriginal fishery to basically nothing. You had to get a permit to even go out and procure fish for your own consumption. When the Constitution of Canada was patriated in 1982, it had a section called Section 35 that protects Aboriginal rights. And over time, as I mentioned, those rights of individuals to fish and communities to fish had been cubbyholed. They were really almost non-existent. And Musqueam struggled to attain the right to fish, to get a license to fish for individual community members. That did happen, and subsequent to that there was some legal matters that occurred where the length of the net had been set at one length, and then the Fisheries and Oceans reduced the net length. There's a number of people who volunteered to challenge Fisheries and Oceans arbitrary regulation of the net length to 25 fathoms, and they repeatedly went out and fished in front of the DFO vessels with a net that was longer than 25 fathoms. And the end result is that I think there were two or three people charged, and my brother's, Ron Sparrow Jr., was taken as the best case to go to court and prove an Aboriginal right to fish. He wasn't the only one, but all the facts seemed to lead to his as being the best scenario for being successful in court. And it did go through all levels of court to the Supreme Court of Canada. And the end result is that DFO was told that they can't regulate our rights out of existence, that we do have the right to fish.